Okay, hello everyone. My name is Marcio Katz. I'm the Chief Operating Officer for GetGlobal International. For those who don't know, GetGlobal is an international data privacy consulting company. We operate in the US, in Europe, and Brazil. And today we are glad to have Victoria with us. And every Monday, 1 p.m. Eastern Time, we host our data privacy online class. And Victoria is going to talk about, actually, she's going to compare the CCPA, the California Consumer Privacy Act, and the brand new CPRA, the California Privacy Right Act. So, Victoria, thank you very much for being with us today, and I'll leave it with you.
Thank you, and thanks for the invitation, and hi, everyone. For those who don't know me, I'm Victoria Beckman. I work at First Round Todd. I'm based in Columbus, Ohio, and I'm the co-chair of the Privacy and Data Security team, and chair of the Latin America desk. And so what I'm going to talk about is I came up with this chart comparing CCPA and CPRA to try to make it a little bit more digestible and more visual. And then from there, we are going to discuss and develop some slides about the differences. I did not add or throw GDPR in there, but I will mention along the way some things that are similar to GDPR. So let's start and see if I can share the screen. I was kicked out of the house to the patio, so this is not my normal setup, and I'm not very good with this one, but let's try. Okay, I hope everybody can see this. So the California Privacy Rights Act will be effective on January 1st of 2023, and it regulates for-profit businesses that have an income of more than 25 million, a net gross income of more than 25 million a year. And just like CCPA, it doesn't specify that this income has to be in California. So we're assuming this is global income for the company. Or that buy, sell, share information of more than 100,000 consumers. This is one difference with the CCPA. The CCPA has a threshold of 50,000, and similar to the CCPA, it has 50 or more % revenue. Derives more of that revenue from selling or sharing the information.
Okay, Victoria, just one thing, you are not sharing your screen, so I think you need to
hold on, because it's sharing on mine. Okay, let me go to the presentation. Okay, what about now?
Not yet.
No.
No. Just press share screen, and it's going to start sharing your screen, and then you can choose your presentation to be shared. Okay. There we go.
Okay.
Yeah.
Now?
Yeah.
Okay.
Yeah. Perfect.
Sorry. Okay. So this is the slide that you just talked about, and as I mentioned in the beginning, this kind of started with a chart comparing the CCPA and CPRA, and I posted this on LinkedIn, and I can, it's in our firm's website, and I will have no problem sending the PDF to anyone who requested it. So in any event, I divided it in categories. One is the scope. I'm just going to go through this very quickly, and then I'll explain everything in detail. Basically, where it applies and in what situations it applies, what kind of consumer rights it has, and what are new rights given by the CPRA that we didn't have in CCPA, the obligations for the businesses, which now, if they were ready to comply with CCPA, now they're going to have to take some extra steps to comply, and then enforcement and a new concept of a dedicated privacy protection agency in California that will take care of the enforcement rather than the Attorney General's office. And some of the exceptions that we have seen for employee and business-to-business information under CCPA also apply under CPRA and are extended another year as well, and a new link that you need to add in your homepage. So this is kind of a broad overview of the differences. The X's are things that obviously you don't have. So when you look under business obligations, if you look at the requirement to have a data protection officer, for example, or whether or not you have to adhere to the rules of cross-border data, is not required, which is required under GDPR. So that will be one of the exceptions, I guess. But if you think about it, and you're a company that has to comply with GDPR, then you're going to have to comply with everything anyway. Okay. So as far as the scope, and I have my little chart here, so I may be cheating and looking a little bit at that. As far as special protection of minors, both of them, CCPA and CPRA, have similar requirements in terms of defining what the opt-in for minors between 13 and 16, and why you have to provide notice and how you have to obtain parental consent. So those things don't really change much. In terms of the business-to-business and employee data, the CCPA recently, I can't really remember, it's been a crazy year, but about 2-3 months ago, they extended it to apply until January 1st, 2022. And then the CPRA extends that as well until the end of 2023 or January 1st, 2024. And what that is that the information is not covered, the information that you collect related to employment information or information in a business-to-business setting is not under the scope of the CCPA, but you have to, you still have to provide notice at collection to employees, and they still have a private right of action in case of a data breach that we will talk a little bit more later. That is a right that is given, so you basically have the obligation to keep the information protected anyway. Something new that the CPRA brings is restrictions on sensitive personal information, or SPI. Well, first, it actually has a definition of sensitive personal information, which is not in the CCPA, and this is very similar to special categories of information under GDPR. And it has restrictions in terms of providing notice, what you can collect, specifying the types of sensitive personal information that you can collect. And there is also some right, and we will discuss it later, to restrict the processing of this information. So what is new here for practical purposes, I guess, and for companies, is that in addition to the link that we already had in the homepage to saying do not sell my personal information, which also changed, but now we have to have this link on the homepage that says limit the use of my sensitive personal information, or you have to require, or you have to support opt-out signals, which that requirement is in the final regulations in the CCPA in terms of reading the do not track signals. But then there is this requirement that if the consumer has some kind of universal do not track signal, you have to understand that as opting out and limiting the use of sensitive personal information. Sorry. Okay, so this is kind of the main stuff. The consumer rights. Right to know is in both CCPA and CPRA, and the right to know includes this kind of look back provision where you have the right, as a consumer, you have the right to know the information, the categories of information that were collected, 12 months, and whether it was shared or sold for the 12 months prior to your request. So the same happens with CPRA, which means that even though it's effective on January 1st, 2023, it applies to information collected during 2022 because it's the 12 months prior. And I'm going to get so confused with all these dates, but it also allows the right to access the information. And there is a new right, or at least new in California, but that we have known from the GDPR, that is the right to rectify information and make sure that it's accurate. There is the right to delete and the right to restrict processing, which also, and what I have in yellow here are the kind of new stuff in CPRA. It gives you the right to restrict the processing of information, and as I mentioned, to restrict the processing of personal sensitive information if you requested it through that link. There's the right to data portability. There's the right to object to the processing of information, which is new, which we have it in GDPR as well. And the right to limit the use of that sensitive personal information that you collected. And this includes a specific geolocation. So you have the right to ask not to disclose your geolocation at least as close to 250 acres from the consumer. There is the right to reject automated decision-making and profiling, and it has its own definition of profiling. The browse with no pop-ups or sale of personal information, and the right not to be discriminated. So in terms of personal rights, it adds something very similar to what we used to under GDPR, which means that in practice, companies will have to change their privacy policies to inform and notify consumers of these new rights. They will have to go through the same process that they went when getting ready for CCPA, as far as documenting the internal processes of how to receive the request, whether or not they're going to be manual or automatic, what kind of pop-ups or notices will be available in the home page, how to process it, how to respond to them, and how to keep documentation of all these rights. So at a minimum, CCPA requires that you review your privacy notice every year, and now with this, you're going to have to review it and modify it anyway to add this. And I should say that if during the presentation we have any questions, I guess you could ask them. I'm not sure, Marcia, if they could ask them in a chat or how we're handling that. Okay. Business obligations, as I mentioned, we have the same requirement to have a privacy policy where we disclose, and when I say we, I'm talking as if I'm a business, but where the business discloses the categories of information that are collected, whether it's shared and with whom, and the rights that the consumer has. The CPRA has a new requirement to introduce and use the concepts of data protection by design and by default. These are concepts that we also that we knew from GDPR, and that involve basically considering privacy protections and safeguards when you are designing a product, by default when to facilitate basically consumers' use of devices, or even why you cannot have like pre-checked boxes and things like that, to basically favor privacy and make it user-friendly towards defaulting to privacy. There's got to be written contracts with processors, service providers, contractors, and third parties. And there is a requirement for service providers not to mix, I guess, information or processing of information that is for the provision of a service and that is personal information as well. It requires, like GDPR, to maintain records of processing activities. So we're back to, I don't know, in 2017, 2018, we were advising our clients to maintain these records of that kind of went together with their data mappings of what what information they collected, where was stored, what was the flow of the information. All those things, you could keep it in a spreadsheet or however you want, but it requires now, the CPRA requires now to maintain those records of the processing activities and the reasons why you collected, or the legal reasons why you collected the information. In both laws, you have to respond to the request, and they have their limitations in terms of days that you have to acknowledge that you received the request and that you have to process and to answer or ask for an extension of time if necessary. And then the homepage links that I mentioned, under the CCPA right now, we have the requirement to have a do not sell my information link if the company sells the information under the definition of sell by the CCPA, which is that kind of broad definition of making the information available for any valuable consideration. Doesn't have to mean the exchange of money. Now, interestingly, they require this do not sell / share my information, which means that you have the right to restrict the sharing of information with third parties for targeting advertisement. And you also have to have this link that I mentioned in the beginning to limit the use of my sensitive personal information. Both of them have the requirement to implement appropriate security measures, and what appropriate security measures is not necessarily, what is appropriate is not necessarily defined, but under other laws, and there's been multiple panels and discussions about what it is and whether or not complying with industry recognized standards will be sufficient or considered appropriate, and whether you take into consideration the nature of the information, the size of the organization, the complexity of the processing, and other elements that you could take into consideration to determine whether or not you actually have an appropriate security. There's a notification, a security breach notification, and then we will talk about the private right of action. It does not have, as I mentioned, neither of the laws have the requirement to do a DPIA, or data protection impact analysis. It doesn't require data protection officers, and it doesn't mention anything about cross-border data. But the cross-border data we know in GDPR has more to do with adequacy decisions and whether or not you can transfer data out of the European Union, then that soon is not going to include the UK, and guarantee the same protections that these consumers will have in the European Union if transferring the information to the United States, for example. Okay, and this is something that I mentioned. It says that service providers cannot combine personal information collected as a service provider with information received from other businesses or collected in the service provider's business capacity. And there are some exceptions to that, but this is basically saying that, under CCPA, there were ways to kind of get around the definition of selling the information if you say that the information was only being transferred for purposes of the service that was being provided. Here is actually requiring that you cannot share, that you cannot combine that information. So I think this standard is a little bit higher in that you have to separate the information that is solely for the business, as a business provider in that capacity, just to comply with that contract. Okay, and this is also interesting. It limits the collection, use, retention, and sharing of personal information to what is reasonably necessary. And we look at this definition again, to achieve the specified purposes. So you have to get rid of the information as soon as you don't need it, basically. But it also has a requirement in terms of your personal sensitive information that you need to disclose in your privacy policy for how long you're going to retain that data, And if you cannot give a specific amount of months or years, you have to explain kind of the rationale for that. So that's a new requirement that you need to add to your privacy policy of how long you are going to keep that information. And enforcement, this is kind of very different. Right now we have, for the CCPA, we have the Attorney General, which is enforcing the CCPA through the final regulations that were modified again in August, I believe, of this year. Well, they were approved, and there were some non-really substantive changes in August or September. But basically here, it will create a data privacy protection agency that will be a dedicated agency. It will be funding, it will have different funding, and it will take over over the Attorney General's office for enforcement, the California Consumer Privacy Act, CCPA, as amended, and then will also enforce the CPRA. And they will be in charge of also issuing regulations later on to explain and provide some guidance as to how it will be enforced. There will be the same penalties, or the concept of penalties or civil fines that we have for CCPA. And there will be a private right of action for violation of certain personal information. Under the CCPA, we have this private right of action for violations of certain information. Under CPRA, we also have the same, but it adds some other categories of information that, if violated, will be considered a breach that gives you grounds for this private right of action. Not for violations in general of the acts, is only for that. Okay, so the California Privacy Protection Agency that I mentioned will have to issue regulations and identifying the business purposes for which service providers may use this personal information. And this is similar again to the legal basis that we are used to under GDPR. It will have to update and define this definition of sensitive personal information, what's identified, and unique identifiers, establishing when service providers and contractors can combine that personal information from multiple sources. As I mentioned, there is that restriction, but there are some exceptions. The CPPA will have to explain that. And defining a specific piece of information to minimize delivery not helpful to consumers. So as I say here, an example is technical data. And that's as far as I have for the slides, because I was trying to leave time for everybody to give me to ask any questions that you may have.
Okay, thank you very much. And we do have some questions here. Victoria, do you think the CPRA is a more GDPR-like regulation? And if so, why?
I do. I mean, as we saw, there are additional concepts that we didn't have in CCPA added here. And I think it is trying to, well, we have here that the promoters and the creators of both the CCPA and CPRA were trying to get to that stricter, I guess, privacy restrictions to protect consumers. So I think that's the ultimate goal, to get it closer to that. And we see, similar rights. We see this California agency in charge of enforcement that I guess will be the equivalent of a supervising authority under GDPR. Additional rights to access and rectify the information, for example, additional notices required. So I do think that is a little bit closer to GDPR.
Okay. One more question. What do you think that would change in a project to help a company comply with the CPRA compared to a project helping a company to comply with the CCPA?
Well, I think, well, they're not the same. Just similarly to when we were working on CCPA, companies that had already done the work to comply with GDPR, for example, were farther ahead, and it was easier to kind of take extra steps to comply with CCPA. I think in the same way here, if a company is already complying or very close to complying with CCPA, it will be easy. It will take, for example, as I said, reviewing the privacy notice and adding the language that consumers have extra rights and that they may be enforced by a different, not by the Attorney General, or that they can restrict their personal sensitive information, things like that. Maybe reviewing the processes that they already have to receive and respond to consumers' requests, to do the same for these new rights, document those processes, see if the timing is the same, see how they keep the evidence. So for companies that have already done the work for CCPA, it will be a matter of reviewing and maybe adding some things. Obviously, from a technical standpoint, you will have to add extra links, maybe pop-up notices. That is not necessarily very hard to do or that much expensive. But if you are not there yet in terms of compliance with the CCPA, then it will be a lengthy process, because it's just not here, there's my privacy notice and you're in compliance. You have to, review contracts with providers. You have to make sure that you have those processes for consumer requests, that someone is in charge. So for those companies that are not there yet, I will, depending on the company, it will be months probably that will take to get there.
Okay, but under the CPRA, companies, they need to keep track of more things and different things.
Yeah.
And information compared to obligations they would have to fulfill compared with the CCPA. Would that change?
Well, they do have to, and again, I'm kind of assuming that for CCPA, companies did the exercise of doing the data mapping, and so they have that documentation of what data they have, when they collect it, and what they do, and on what basis. So if that's the case, yes, they will have to make sure they have it documented. They will have to keep track, for example, of those and comply with the request to not to process the personal sensitive information. They will have to actually establish a mechanism to do the do not track, to follow the do not track request. So yeah, obviously there are more requirements in general, but again, and maybe very naive of me that you assume that companies have been doing that in preparing for GDPR, for CCPA, and for just privacy compliance in general. Yeah, but I realize that that's not true in practice.
I don't know. I mean, I feel that some American companies, that had to comply with the CCPA, some of them have done and the data mapping or data discovery, but not. I feel that most of them were not so worried about the life cycle of the personal data, and more knowing what kind of data, if it's a personal data or if it's not a personal data, and if it is a personal data, where we are storing the data. It's more about knowing what kind of data we process and where we can find it. But when it comes to the GDPR and closer to the CPRA, it's more about the life cycle of the data. So by keeping track of the life cycle, we need to know things that maybe we didn't have to ask during the data mapping for the CCPA. So I was wondering if we may have to address a new data mapping to discover new things that we need to keep track of it.
Right. Well, and that's the issue when data mapping, regardless, even when you were doing data mapping for GDPR, by the time that you're done with your data mapping, you're outdated already, because some processes have changed, some information has come into the flow. And yeah, you're right. I think that was kind of a shock with GDPR, especially for US companies. It was a little bit of a shock also with CCPA, and now they're just going to have, they're going to realize more and more that it is important to know why you're collecting the information that long. Where are gone the days when you just wanted to know everything about your consumer and what they like and what they did and where, everything, and kind of this concept of big data to know very well the consumer, to actually sit and think, do I need this? Do I need it for this purpose? And what is the risk? And even though it doesn't require that risk analysis, you should always do the risk analysis of, do I really need this information for, I don't know, do I need to ask for your date of birth if I'm going to sell you a t-shirt? So I may know more about my demographics of my market, but is it something that I need to risk having it, so that if there is a data breach, then the risks and the consequences are higher. So it does require that, but I think it's a good exercise for companies regardless.
Yeah, definitely. Yeah, at the end of the day, we have to ask so many different questions when it's a GDPR project compared with the CCPA. We need to know where that data can come from, why we're processing that data, who has access to that data, where we're going to store it, are we going to share it with any other company, why we're going to share it. Is it necessary to share the data? So many questions that we didn't have to ask if we were just addressing a project to comply with the CCPA. So I feel that now we need to address and manage projects to comply with the CPRA. We might need to come back and ask some questions that we didn't have to ask before. And that brings me to another question here. Do you think companies will need data privacy softwares to help them comply with the CPRA, especially because they need to keep some records regarding the new law?
Well, I think that's a question that I get a lot. And I think it depends on the company, obviously, and the kind of information. If it's a big company, obviously software always helps and keeps I think my signal is so they can automate the requests if they need to. If it's a smaller company, if it's a company that requests personal information but maybe just process an order, then you may be able to do it manually in Excel spreadsheet or something like that. But obviously there are programs that are good not only in keeping you and assisting you with the request, but there are all kinds of programs that help you with that kind of data mapping and telling you where you have personal information and what are your riskier areas. And it also helps in terms of a breach, for example, to identify and to know. So if there is a breach and let's say a ransomware, and all the servers are encrypted, then you know what information was there and what servers you need to be concerned about. So I don't think it's a requirement for all companies, but it is definitely helpful. It could be done manually if necessary, if it's a small company, I think.
Okay, so it depends on the core business and the size of the company.
Yeah, I have clients that are fairly big companies, but the information, although personal, that they collect, as I said, is mainly name and email, or name and address, and they don't receive that many requests because of the nature of their business. So they rather keep it manually because it's more cost effective. Some other companies are constantly, like in retail and stuff, constantly receiving requests, and they can't keep up, so they have to have a software.
Yeah, sometimes it's a small startup, but they process, a large scale of personal data. Sometimes they do need this kind of software just because of the core business. Okay, just one last question here. CPRA requires cybersecurity audit annually. Is it by external or internal auditors?
Well, I actually had this question before, and I don't think, and I may be mistaken on this, I can't remember the exact test, but I don't think it specifies whether it has to be internally or externally, because it talks about cybersecurity audits, for example, having checklists that organizations can use to validate their own security policies and procedures. Depending on the industry, there are organizations that require external audits, for financial reasons and tax and you name it. But I don't think that as far as I'm aware, I don't think that the law requires that it has to be an outside company that comes and does that. Now, again, there's the question of what's reasonable security, and based on the interpretation that has been given in other laws. For example, here in Ohio, we have a safe harbor provision, formerly SB 2020, that, 2020 is the year, 220, that says that it provides an affirmative defense to a company that can demonstrate that company follow reasonable security standards. And to demonstrate that, you just have to show that you comply with something similar to an industry, in that if you can demonstrate that, you can say, for example, I follow NIST, I follow ISO. You don't have to show that, PwC came and did your auditing.
Yeah, we have so many different standards, like you mentioned it, NIST or ISO, and you are one of the best data breach lawyers. So it might be a good idea to talk with a specialized lawyer to know, what would be the requirements for that specific state. So yeah, and
it's not the same as far as data breach goes. It's not the same. Some laws don't define what you have to have. Some industries are heavily regulated: finance, health, insurance. There are some requirements in the insurance industry. So what I normally, for example, for this affirmative defense in Ohio, I work with the IT person to say, well, what is it that you follow, and will it pass muster under the law? And also, if the company is having external auditors kind of on the same line.
And keep track of the court decisions. It might be a standard, because you can compare to previous decision what would be the standard to be followed. So
well, and the law in Ohio, for example, does explain that what's reasonable security varies depending on the type of industry, the size, the core business, a lot of different factors that could be considered in that. There are some other definitions as to what standards need to be followed. For example, in the insurance model law, defines, I think, is 8 or 9 specific standards that could be followed. The NIST and ISO that I mentioned, HIPAA, things like that.
Okay. Well, that's it for today. Once again, thank you very much for being with us. And once again, guys, would be glad to invite you to attend the next Monday data privacy class, 1 p.m. Eastern Time. And Victoria, thank you very much for accepting our invitation.
You're welcome. Thanks for inviting me. Always a pleasure.
Okay. Yeah. Thank you, guys. Bye-bye. See you next time.
Bye.